Court does call the case of the People versus James Whitley.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm here with James Whitley.
This is People's emergency motion to modify violence in this case.
I find it surprising that they're alleging that she's in danger, the prosecutor, and they don't call her to show up. She reached out to a friend of my client.
Call her to show up to do what?
Today to say I'm afraid. I mean, I will say,
Mr. Bennett, you've been doing this long enough. You know that's not going to happen.
I don't know, at 3 o'clock with 24 hours notice, I couldn't have got a hearing in that.
Could have got a hearing on what?
If this was reversed.
Absolutely. Oh, do not even insult this court by saying that, Mr. Bennett. Do not, because you would have gotten a hearing. Had you filed a motion, had you requested that it is an emergency hearing, the public defender's office does it all the time. The fact you don't know how to do that and think that this court is playing favorites, you're wrong. Say this, Mr. Bennett. I've been on this bench almost 25 years and never
shifted gears. The judge isn't simply disagreeing with the defense attorney. She believes the attorney questioned the court's fairness, and that's one of the quickest ways to escalate tension in a courtroom. Judges expect lawyers to challenge rulings through legal arguments, not by implying bias. What do you think? Did the defense cross the line, or was the judge overreacting? Let us know in the comments.
Have I ever been insulted in the fashion you just insulted this court? No. My turn. The first case I called today was upon receiving a notification about something that I had considered in a bond. Was notified that had been located. This court, to the defendant's benefit, set that hearing without notice to any side. I set the hearing. So to be fair to all of the parties. I received motions all the time regarding bond. And this court just seeks to have a hearing. Now, having said that, so maybe you can put that in a little perspective. I heard you that you said discovery can't go through. Well, I'm going to give you about another 18 hours to go through, because I'm adjourning this hearing for 2 to allow you to go through to give me a cogent argument as to why I should not grant what the people want. And secondly, because you have raised the ire of this court. I am not going to punish your client by what was the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. I will not by any means punish him for that. I do not make my decisions out of anger. I'm adjourning this to tomorrow, May 10th. New. All the parties are ordered to be. That is all. That is all. New. Tomorrow. This is a continuation. Is there anything additional from the people? Anything additional from the defense?
Nothing, yes, Your Honor. One thing is that if the court finds money bail, they stop this hopefully bail be something like 10,000. The current bond can use specific tether with the exclusion zone and the drug and alcohol. I think address primary concerns in the report. He was intoxicated, he should not be. But the reason I primarily the 150 successful. It's no history of any violence whatsoever. In fact,
Well, can I just stop you there because I have some concerns about the representation of what happened that were made to the magistrate at the time, and some of them made to me yesterday. I went back and listened to the arraignment. And my understanding is that the alleged victim in this case contacted the defendant to pick her up from Chelsea Bowling Lane or something along those lines.
He went to Chelsea Lane, make sure she got home safe. Because she was intoxicated.
Right. And then after that is when this ensued. I'm having difficulty. Well, let's put it this way. He, according to what I have, he shouldn't have been driving. That's number one.
It wasn't tested. The allegation is that he was intoxicated. I don't believe he agrees with that characterization.
Mr. Bennett, do you know what you said at that hearing regarding intoxication? Well, first of all, I don't think there are two issues there. One, he wasn't. My understanding is his license is revoked with restrictions, and that his activities in going there that night would have been within his restrictions on his license.
Okay.
Right. Secondly, with regard to the incident, the indication is he was trying to get his keys to then drive again, which would have been outside of his license. And there was at least the indication when there was a talk of intoxication that the defendant at that time made very intoxicated.
I believe I said exactly that I may have been intoxicated. Can I stand concerned or not?
Go ahead.
Your Honor, if that's the concern is that he was driving habits, then an added condition, driving license.
No. My problem is with the whole story. Because he why is he getting to drive when he's not supposed to be driving? Is what I'm having difficulty even understanding the events you're telling me they may have existed at that time.
She was intoxicated. Chelsea Lane. Wanted to try to drive her. She refused. She drove her cell phone. I think I even seen alcohol with this. I don't know if that's followed her. Make sure she got there okay. The party generally, I believe, according to reports, spent most nights there. Then they got into an argument, tried to leave, couldn't find his key. That's when they hit the bed, the phone, and the glass break. I think, in my opinion, those sort of discrepancies are only the absolute truth, relevant bond, but they deeply likely should have convicted. She have the alleged victim said statements were entirely accurate. And him saying looking out for her. When the argument got lost, he asked her to keep.
This is the turning point of the bond hearing. Remember, a bond hearing isn't about deciding guilt or innocence. The judge's focus is whether the defendant poses a danger to the alleged victim or the community and whether they're likely to follow the law while released. Conflicting stories, alleged injuries, and driving despite license restrictions all become major factors. Would you have reduced the bond, or do you think the judge made the right call?
The children wouldn't hear them argue he was concerned about trauma they experienced from a prior abusive relationship. Telling her to calm down, that's when it gets that habit in the bedroom. Which there's disagreement about what that was. If that today resulted in the injuries sustained by the alleged wrists, arms, I would clear up some shit. There were actually the people said there were 3 kids, 3 extra. I was able to do what they provided. But I think that the issue is bond is somebody close friend. The alleged victim is known Mr. 1 year. He said he's not. This has never happened. So regardless of whether or not there's conviction purposes of bond does not.
If I consider him a danger, yes. I mean, what I've got here is somebody that shouldn't be driving, who may have been intoxicated, who would have driven on two occasions when he's not supposed to be driving, in violation of restricted license law. Then I have this confusion about the incident. I don't even know why he would have his keys now as you're related he drove and then followed her, which was not the indication that I got to the arraignment. And then an altercation occurs that results in what I would consider significant injuries to the alleged victim in this case, to the point of a level of medical care required that person, which I think significant. And then from that, does she have to keep moving? And then it creates in this court's mind a level of potential danger that this individual poses potentially to the victim as well as to the community. It certainly raises because he's not law-abiding person. That should say he is obviously driving. He's got this previous conviction, revocation of his license restriction, and he's violating that twice that night, at least. So I don't know. Sparoso, was there something else?
No, you're right.
Anything else, Mr. Bennett? Anything else, sir?
No, I just don't get it. Was driving. It's violating this restriction. It doesn't warrant 100,000. You think that some cash bond is appropriate this one. It should be something that powers.
Understood. And what I am additionally indicating is that in listening to what was said at the arraignment regarding what transpired, listening to what that day, hearing what is today, it's unclear to me that that's what actually happened. Because that's not been said. Defense side about how this whole thing comes about, and then end up with an individual that is severely injured at the hospital getting the treatment that they're getting. There's some indication that that's her fault. Maybe, but then. And that the defendant is trying to get away. Find that version of events. It may indeed be true, but at this point, to be sort of remarkable that would be it. The court. Go ahead. What are you going to say?
I was just going to say,
Oh, I'm sure it certainly will. I don't have that at this. Normally bond hearing. I have to assess it based on what I see, and I would say also, with all due respect to the magistrate of this court, that making a statement of giving a PR indicating people file an emergency bond motion. I do not know. But that from my perspective leads the court to believe that it was in part, but also as a result of looking at it, would find that a decision bond was exceeded discretion in issuing that bond. The court will leave all of the conditions that she said in place. They will set the defendant's bond in the amount of $35,000 cash surety. Defendant, your matter.
Thank you, Your Honor.
Court does call the case. People say to Michigan versus James Witt.
On behalf of the people.
Good afternoon, Your Honor. For the record, James Whitley.
Thank you. All right.
Counsel and I have.
Yes, you may.
14A District Court for the Office of Michigan.
You may be seated. Back on the record in Michigan versus James Whitley. Typically. Oh, go ahead.
Go ahead. Thank you. No full use on behalf of the people.
Good afternoon, Your Honor. For the record, he appears with now. He is sitting to my right.
Typically, the court doesn't publicly discuss. Will apologize. Misuse, and I will allow certain counsel to say what they want to say or need to say. The court doesn't discuss bench conferences, but I think under these circumstances, I'm going to certainly disclose that. Misuse issue that you brought to the court, unless you have some strong objection.
I have no objection. Thank you.
The court has been informed that at least the defense counsel has indicated that should this exam begin, that it may be his intent to grieve the elected prosecutor for pursuing this case. Court has some concerns with first and foremost that posture in and of itself can have a chilling effect. Just proceedings and may be an attempt to interfere in these proceedings, may in and of itself constitute a grievable offense. But also that this court, if that is indeed the allegation, would not proceed with a hearing that would require someone to then commit a grievable offense. Ms. Hughes also disclosed that she, since we're not pertaining to command to seek their advice, she should do what she should do. It was ultimately said, I think at one point, certainly bring it to the court's attention, which I think is appropriate. Since it's under. Mr. Bennett, I will ask you whether or not you believe in this case that the people in proceeding are committing a grievable offense. And if so, will you just state on the record what that offense is?
My concern.
Not asking for your consent for you. You have made an accusation that what?
The committee agreed agreeable.
Do you believe that in studying this exam that they would be committing a grievable offense?
No.
Was that said to the prosecutor?
That said, I don't believe it was in the manner that was described. Certainly.
Tell me how it was said.
There were two things. One, do you want me to ignore the one you didn't disclose?
Tell me how it was said.
What I said was that I believe that if the state were to go forward, that it would be grievable because I believe that the prosecutor is not following under obligation under the Michigan rules of professional.
Which ethical obligation are they not following for?
The two that I concerned about one is determining what the actual facts are, and the two is prosecuting somebody who may in fact actually innocent. What I did was offer she felt that it was appropriate wanted to discuss with the alleged victim why we could adjourn this out. You can talk to her and decide how to go forward. So my only concern is that he didn't make contact with the alleged victim who now has a different story. No longer that's a problem.
Is that even as you describe it to something that is grievable?
It doesn't.
And why was it said?
Because at the time I believed that it was grievable.
What changed?
Honestly, what changed was I wasn't aware at the time that they had the lay witness here, and so the presence of the lay witness, I think it eliminated issues I had. Police provide the testimony that's admissible here, but not.
Miss Hughes.
I absolutely intend on proceeding pursuant to CL 716. I have made no statements to Mr. Bennett about Potter being present. I also think Potter is not present.
Explain to me, Mr. Bennett, how that makes a difference. Because quite frankly, I think your accusation against the prosecutor amounts to your attempt to obstruct these proceedings. So explain to me, which in and of itself would be grievable, counsel. So explain to me what happened now that you know that they're there, how that changed the whole mindset.
The proceeding with statements that were exclusively be inadmissible at trial, and going forward on those. These are confrontation issues.
There's a statute which covers.
I understand. My concern was it goes on those statements, and now they proceed to trial. Because at that point, confrontation is going to attach. At trial.
Why would that be grievable? If they proceed pursuant to a statute promulgated in the state as well as a court rule which covers that. Why would that be grievable at any point?
My concern was not determining the facts of the case that are present evidence today.
If they believe those facts, but for a hearsay objection would come in. That goes not at all goes to their determination. They may believe that to be the case.
I understand.
So how would that even come into play? Mr. Bennett, I mean, how does that even come into play?
I explained what my positions are and what else to say.
Okay, let me just say this. I don't care if somebody's on the defense. I don't care if somebody's on the prosecution side. Doesn't matter. Especially between counts. No one is ever going to come into this courtroom and be intimidated in some way by some of their profession, particularly in proceeding with what is their obligation. It is his obligation to bring this case. It is your obligation to defend your client. She can't make threats to you to prevent you from proceeding to defend your client, or to do nothing. If your client wishes to do that as the defendant. This behavior, that behavior, Mr. Bennett, is inexcusable in this court. Absolutely inexcusable. And quite frankly, sanctionable. Because you can't try to make somebody not do something by quite frankly, as I'm listening to your explanation, absolutely unequivocally false threats to their livelihood. What do you think you were doing?
Trying to bring to this attention that may or may not exist. She interprets the threats, which I understand.
I'm going to agree with your boss. And you, if you start this exam, she's supposed to take that as something that should be brought to her attention as opposed to a threat.
We continued our discussion the second time where I was coming from. I did not say what I said very artful way. So
you threatened to grieve for her proceeding. Am I wrong in that?
I didn't consider that I threatened trying to bring an issue forward. Right.
She took it as a threat. What was she supposed to take it as?
She took it how she took it. I mean, that was a mistake on my part. I acknowledge that.
You're trying to tell this court that you didn't intend to threaten her boss, and ultimately her. Is that what you're telling me, Mr. Bennett?
I was trying to bring I saw it as an issue. I unfortunately started
the issue being what? Their use of evidence pursuant to the courtroom, which is why we have these hearings, why you have the ability to object, and this court would have to rule.
Well, this case was different because it's a different situation where this is a situation where alleged victim is more another detailed statement as to what happened.
And so what makes that different?
The duty to investigate the facts.
How do you know they haven't?
Besides telling me that they haven't, I don't know.
But I've never told him the information. I've never told him about the many contacts that she's had with my office. I've never told him about put on the record that she's hearing at the hearing. You're on in at hearings that Your Honor has presided over. The letter that was turned over to the police department was turned over to the defense. And frankly, has never asked. He just came. I'm going to Ellie Savage.
Bennett, I am very concerned. What was your intent on saying that?
I intend.
I'm going to stop you right now because I'm going to tell you something. You need to be real careful because I may have to consider grieving you.
I understand that.
And I don't think you want that.
I certainly don't want that.
So what I'm going to do I'm going to take another 10-minute break. And I'm going to come out and ask for your explanation before I decide on anything but I will let you know, Mr. Bennett, with regard to what I've heard of you are walking on real thin ice, not just with your ticket to practice. Court's in recess.
All rise. District Court, State of Michigan is now
Maybe seated. Back on the record, in case of the State of Michigan versus counsel is present, as well as the defendant. Is there anything else regarding this issue that either side would like to say?
Your Honor, I'm going to self-report the file under Professional Conduct Section A, subsection A. I agree that I gave the inappropriate message to prosecutor. I apologize for doing that. I feel obligated to report myself.
We will see if that happens. The court hasn't made a decision as to what should report you. Mr. Bennett, I am going to tell you, and all the years I've been here, counsel, and even when I was down, counsel says to each other, maybe not meaningful necessarily. They'll say things out of anger to each other. I don't know why you would even think it would be within the bounds of anything decent that kind of threat. And I call it a threat. That's precisely what you were doing. And I have to make a decision now, knowing it, as to whether or not I should. And I will make that decision. Miss Hughes, and I'm going to apologize on behalf of the court for having to do this, but I think it's necessary given this turn of events. Would your lay witness, as well as I guess the officers, be available on July 1st at 10?
Is it at all possible to have the lay witness testify to identification?
As to identification of.
So it's very brief, and I don't want to have to bring the lay.
Understand. Mr. Bennett.
I would stipulate the identification.
So you're stipulating the person sitting beside you is Whitley, and that he was in a relationship with Jennifer Potter on April 27th, 2024.
Yes.
Thank you.
Will that satisfy what that witness would testify to? Very good. Thank you.
What was the date? I apologize.
I am going to adjourn this for everybody to July 10 a.m. That is my only.
July 1st.
I realize that gets close to a holiday, but will that work?
Yes. Thank you. Thank you.
That's fine. I will adjourn it. Mr. Bennett, please apprise this office as well as prosecutor if you're going to self-report, so that maybe others of us don't have to take any action.
Yes, Your Honor.
Preliminary examination in this matter is adjourned. July 1st, 2024, 10 a.m. Thank you.